I'm Linda Brayman with Senior Moments. In the heat of the day, when it's just too hot to step outside, don't waste your time worrying or wondering about what you should do. Just tune in to Senior Moments and learn something new or interesting. Senior Moments covers events and activities at senior centers in the Ann Arbor, Ypsilanti area, such as the Ann Arbor Senior Center, Turner Senior Resource Center, Pittsfield Senior Center, and the Ann Arbor Community Center. Also, the show provides valuable information for senior citizens on such issues as health, wealth, finance, and entertainment. The program premieres on the last Saturday of the month at 5 p.m. and it reruns 10 times a week on CTN Channel 16. Also, you can watch the show on YouTube. Please log on to youtube.com CTN Ann Arbor to view current and archive shows. Stay tuned and enjoy the show. Welcome to Senior Moments. I'm your host, Linda Brayman. I don't know about you, but I've been hearing a lot about estate planning lately. Maybe it's just my age, because even my doctor keeps asking me if I filled out the forms for estate planning that she gave me yet. I haven't. So I'm very excited to have as our guest today, attorney Terry Bertram from Ann Arbor, who specializes in estate planning.
Thanks for having me today.
I am really anxious to find out what all the fuss is about with this estate planning. But first, can you just give us some background on yourself?
Sure, I'd be happy to. So I was born and raised in Traverse City, and I'm one of those transplants. I came here to go to school at the University of Michigan, and I never left. And so I've been privileged to have a law practice here for 30 plus years. This is the area of law that I spend my time on in terms of working with individuals and families and helping them plan for their affairs when they're not around, whether it's because of death or incapacity, and working to make sure their affairs are in order.
So that's basically what estate planning is then, getting your affairs in order?
Yes. So, sometimes people say estate planning, that sounds like you have to have a lot of money to do it with, but it doesn't matter what the amount is. And it's not just about money. It's also about ourselves. And you mentioned that your doctor is even asking you, because now with the Medicare program, it has encouraged doctors to ask their patients on whether or not they have an advance directive. Oh. And an advance directive is a document, it's got a lot of different names: healthcare proxy, healthcare power of attorney, patient advocate form, but it's, have you indicated who you would want to make medical decisions for you if you couldn't make them for yourself? And also, at least as important, is what would you want or not want if you couldn't make decisions for yourself regarding end of life, life-sustaining treatment? At the end of my life, do I want comfort care, or do I want you to keep treating me? And even if there's little or no hope of recovery there, and what the balances are between a good life and a long life and things of that sort. So when we talk about estate planning, it's not just about who gets my stuff when I'm gone. That is important, but how am I taken care of during my life when I can't speak for myself?
Yes, excellent. So does any of this require a lawyer?
Typically, yes, in as much as you want to make sure the different things that you have put together will work when they need to. And it's not one of these things that you want to do on your own and then find out it didn't work. And it won't necessarily be you, it'll be your loved ones or whoever you want to help out at that time, unable to. We have seen time and time again where someone is unable to manage their affairs because of incapacity, and people are boxed out of their financial matters or can't make healthcare decisions for them because the tools or the documents aren't in place for others to help them. And making sure that whatever those tools are, that they are comprehensive enough to cover the different aspects of what they are addressing in the moment. So what I tell folks is that we all need a legal first aid kit for ourselves, as well as how we're going to leave stuff for others. And that legal first aid kit should involve what we were just talking about, an advanced directive or a healthcare proxy where you're designating someone to make medical decisions for you if you can't make them for yourself. And what would you want about end of life treatment? But also the companion on the other side is a comprehensive financial power of attorney. And a financial power of attorney allows someone to step in our shoes to make sure, our financial matters are handled if we can't while we are alive. And we want it comprehensive because Michigan law says whatever authority you're giving to someone, it has to be in that power of attorney. When I first started practicing, my powers of attorneys were 2 pages long. I would say, I want my spouse to be my power of attorney. They can do anything I could do, and what we call a blank check. But the legislature found that there were cases of fraud and other things, said no more blank checks. If you're going to give someone the authority to do it, you must state it. So what was a 2-page document now in some instances gone to 25, 30 pages because we want to make sure it's got the breadth of the different things. Do I own a small business? Maybe in the future I need to consider long-term care and I need assistance with Medicaid or veterans assistance to help pay for my long-term care. And can someone do the planning and get my government assistance should that be necessary?
Is the state going to get involved with any of these directives? You mentioned fraud. How do they know about it if they're not involved in it?
Well, first of all, the state takes an attitude that they are there as a default if you don't have your own plan. And so, unfortunately, if we're incapacitated, that involves, and we don't have anything in place, in our probate court, we have what's called guardianship proceedings and conservatorships. Guardianship is for if no one can make healthcare decisions for us or placement decisions for us, but we can't live on our own independently, we're incapacitated. Conservatorship is to handle our money if we can't, where the court appoints someone to handle our matters. And sometimes they have to do both when things are there. But the court doesn't seek to get involved. The first thing, if someone files a guardianship or conservatorship petition, they say, does this person have a power of attorney? If so, we don't need to get in the middle of it. And it's a private thing between parties. And so, the state's there more as a backup if we don't have our own plan. And that's why it's important for us, because if the state is getting involved, one of the things that the court likes to remind us when we are in those types of proceedings, other than someone being convicted of a criminal act, this is the only other proceeding where we're taking the civil rights away from someone and giving it to someone else. And so for them to do that, they want clear and convincing evidence, A, that someone is incapacitated, and then B, that they need this type of help, because it's quite an onerous thing to take away someone's rights. And that's not what they hope to do there. Whereas if I have powers of attorneys in place, I've already designated who I want to be in charge and what I want them to do. And that's always better. So the state's more of a backup, not wanting to be in the middle of our affairs.
So what kind of evidence does this designated person have to show that the person that he is the caretaker of is incapacitated? And physically, I think that's probably pretty explanatory, but my mother is losing her memory and she forgets a lot.
Yeah.
So how do you prove that? Because she'll say, I'm fine, I'm fine.
Yes. So that's the problem when we have with some disease processes like dementia. As I refer to it, it's like a bouncing ball going downstairs. There's good days, there's
Oh.
not so good days, but we
Mhm.
see the gradual decline over time there.
Mhm.
What we suggest that people do is, in terms of financial, have a financial power of attorney that's effective when you sign it. And how I explain it to folks is you therefore have a helper. You don't have to give up control, but you have a helper with you. So it's not either them or you, sort of a thing. If people say, well, I only want someone to be able to control my things if I'm unable to, I then respond with a question. So you trust them more when you're incapacitated than when you're capacitated and you could oversee what they're doing. And I go, it's fine to have it with immediate effect and you give that when you want it. And my mother was a perfect example. She had a serious lower leg problem where she was immobile, but her mind was fine. And so she wanted me to use her power of attorney to do some banking and other things for her, but she was not going to give up control whatsoever. She just couldn't get around. And so I would take that and go to the bank or the other financial institutions and handle some matters for her, but she didn't give up control. So it had immediate effect. Now, with a healthcare power of attorney, typically how that gets triggered is the healthcare professionals who are treating someone are going to tell you, if you're the one who's been designated as a person's, what we call in Michigan, a patient advocate, this person is unable to make their own healthcare decisions. And they have designated you to make that. And it's now time for you to make those decisions. And here's what we're dealing with. So that is only triggered when a healthcare providers say that someone is incapacitated. We who have been appointed, we don't get to make that decision. It's made by others.
Yeah, yeah. It sounds like this is a humongous process. Where do we begin when we want to begin to do what we have to do? How do we start?
Yeah, well, the thing, what I recommend for folks is start with that legal first aid kit. Get your healthcare power of attorney in order, get your financial power of attorney in order. And the third one that we recommend, there's a federal healthcare privacy law that we've all heard of and don't necessarily understand, called HIPAA, that says no one is entitled to our healthcare information unless we pre-authorize them. And so we want to make sure that we all have a HIPAA authorization with the healthcare power of attorney and the financial power of attorney. And then in terms of how do we deal with our stuff, who's in charge and who gets it when we're gone there, at that point, we can have either a will or a trust. A will is a document that you are giving instructions to the probate court as to who you want to be in charge and who you want to receive your estate, your beneficiaries after your death. A will has to go to the probate court to be admitted after your death and for it to therefore have the legal weight to be followed through. So you can change your will at any time up to your death, for that matter. The other way that you can do that, and is becoming much more popular nowadays, is the use of a trust. A trust is a private document that you create and it's often referred to as a living trust because it's created during your life, and you retitle your assets into the name of your trust. And what we know about a trust, it doesn't get sick or die. It says who's in charge if we get sick, and who's in charge and who gets it upon our death. And furthermore, with a trust, we may have minor beneficiaries, beneficiaries with special needs, or beneficiaries who aren't good money managers. And you can say with a trust, it will, they're not going to get their inheritance all at once, or it'll be at certain ages and things of that. So it gives you management during your life, at death, and after death, whereas a will is at death into the probate court. And so it's two different ways of handling your affairs.
So if you go with a trust or a will, even, you put everything that you want, all of your assets into it, and to whom they would go.
That is correct. So with a trust, what's important in any trust that you have is we use the term funding the trust, which means retitling of the assets into the trust. And so, we prepare a deed for any real estate so that it goes into the trust. We prepare assignments for personal property, and we work with folks as terms of retitling their bank accounts or changing the beneficiaries of their retirement plans, depending on the type of asset, because the trust becomes the vehicle. And I tell people, think of it as a wheelbarrow. The wheelbarrow goes along, and who gets it when you're gone? And you want to put your assets in the wheelbarrow so that it is funded, because it says the who, what, where, and when, and what the rules are at that time.
Now, if we have real estate and we put that designated person as, owner also, put that on the deed, what happens then? If I die, does that person automatically get it, or does it go to probate? What's the problem with that?
Well, the good news is it works. The bad news is it's an awful thing to do. And so I strongly discourage people from putting others' names on there. But it works in terms of it automatically conveys it upon death. Now, why do I say it's a bad thing to do? Number one, if I ever needed Medicaid in the future, or veterans assistance because I need long-term care, I'm allowed to have my primary residence, and it's exempt, meaning it doesn't count against me. But if I put someone else's name on there, it's now considered a divestment, and it would make me ineligible for benefits I would otherwise be eligible for. Secondly, when you put my name on it during life, that could be subject to a gift tax. We are allowed to give up to $15,000 to someone other than our spouse annually. It's $16,000 this year, and it's not subject to gift tax. Anything above that. So if the house is worth $100,000, you put one other name on there, that's in effect a $50,000 gift. The third thing, and this is why I always tell people, well, you're adding the IRS as an additional beneficiary. If you give it to me during life, you put my name on it, I will be subject to capital gains tax. And capital gains tax is the difference between let's say mom put my name on there, what price she paid for the house and what it's worth now. That difference is subject to capital gains tax. Whereas if I inherit it, I get it what's called a step up in basis. I get it at that higher value without paying capital gains tax. So, there's potential capital gains tax, there's gift tax, there's losing eligibility for Medicaid or veterans assistance. And then also by making me a co-owner, now mom is subject to my creditors
Oh,
In addition, because I'm considered a co-owner, if something bad happens to me, or if I'm part of that 50% divorce rate, and then it could go to an ex-spouse and what have you, because it's considered my asset too. So what I always tell people is don't put other names on accounts. If you want them to have access to it, get a power of attorney that allows them to then do things for your benefit. And if you want them to receive it, it's always better to receive it at time of death by way of a trust or a will. Don't do the shortcut of putting someone on a deed, even though I know it works, or putting them on an account because I know it works. That's the good news. And the banks or the credit unions or the title or the places where you register deeds, the county register of deeds office, they're not going to give you legal advice as what the tax consequences are or long-term care assistance or anything. They will do what you want, but we don't want you to do that.
That is so good to know. I'll tell you, because I was thinking about that, but I'm not going to do it. I promise.
Right.
Is there anything else that we should know about this estate planning stuff?
Well, oftentimes I get asked, when should I do it? and I go, as long as you know 2 dates, just do it right before that. The date that you're going to get sick and the date you're going to die. As long as it's done before that, you're good. And so that's one of the problems is we don't know. So it's never too early. It's never too late to do something there. And the whole idea is to have peace of mind. We are in a world now where, it's not just the banker on the corner who will do whatever you want because they know you. Even if they do, there's formalities, there's protocols to be followed. And as I tell people, the unfortunate thing about this stuff is it's not necessarily for you. These are documents or tools that you're creating for others to use to help you should you be incapacitated and at the time of your death. And you want to make sure those tools are in place when they're needed, because otherwise we have these fallback methods. We have the guardianship proceedings, we have the conservatorship proceedings during life, and at death, if you don't have anything, there's what's called dying intestate, where the court determines who gets your estate and who's in charge. But that's a long procedure, more expensive, and you're not controlling it. And it has nothing to do with how much money. It's whatever amount you have. You want to make sure you're controlling who helps you out during life and who gets it and how upon your death.
Yeah, wow. Terry, thank you so much for all of this information. It's mind-boggling. I'm going to have to watch again so I can take notes. Thank you so much for helping us today.
Pleasure.
We appreciate your coming. All right, and to our audience, thank you all for tuning in. I hope you learned as much as I have and will definitely get going on your estate planning. If you haven't already, do it now. See you next time. Thank you for joining us on Senior Moments. It can get hot out there, so be careful. Safety first, always. Senior Moments, after you're tucked in safely. And come back as often as you'd like. I'm Linda Brayman. Have a great summer.